Hello and welcome to this month's episode of The Legal Scoop. I'm Brendan Shannon, an associate attorney here at LOMAD. And if you're not familiar with this video series, this is the series where we discuss recent decisional law from either the Third Department or the Court of Appeals. And this month I want to discuss a very topical and interesting subject, even if it's not a good decision for our part. And that's the Jungle v. Maspeth Remodeling Company decision. And if you're looking for the citation for that, well, I'm sure it'll be included in the video. It's 238 83rd 1441. And this is a case where the carrier filed an RFA to reduce the claimant's benefits per its IME. And this is an issue we see all the time, that there's always been kind of differing views on how this should work, but when they got to the hearing, the carrier argued that benefits should be reduced as of the date of the IME, or alternatively, as of 20 days from the RFA. And basically, you want to take the position that it should be reduced as of the date of the IME, because if the IME is credited, theoretically, there's an overpayment. But the reason that sometimes carriers and attorneys on our side will take the position that at the very least it should be 20 days from the RFA is because of Board Rule 300.23b, which provides that hearings on the issue of reduction or suspension when requested should be scheduled within 20 days. Now, in this case, as I'm sure anyone watching this video probably could guess, the claimant argued that benefits should not be reduced until the date of the hearing, obviously then at a tentative basis pending litigation on degree of disability, and that's what the board ultimately held. And the reason that people should be familiar with that is because that's what happens all the time. Except we do get these sort of inconsistent cases, which you can find for panel decisional law on this issue, where either the court was willing to reduce retroactively to the date of IME, or at least 20 days from the RFA. Now here, the court, and this is a Third Department case, so now we're dealing with binding case law, affirmed the board's holding that the proper date of reduction was the date of the hearing. And the reason it did so is because it agreed with the board's interpretation of 300.23b 1 and 2, which basically the board interpreted that as saying that for one thing, benefits can't be reduced or suspended until there's been a ruling by the board that it's authorized. So that has to happen, generally speaking, at a hearing, which is why they didn't reduce till the day of the hearing. The other thing with respect to the alternative argument on 20 days from the RFA being the reduction date, which again, the board used to take that position, the court agreed with the board that that's not a mandatory requirement under the regulation. It's aspirational. Now, we don't necessarily agree with that, and if you read this decision closely, one of the reasons they sort of come to that conclusion is because it's the board's own regulation and sort of a deadline set by the board itself. So the fact that it's not following it, should be excused, which that's not really how regulations work. So we're not super happy with this decision. But the one thing to keep in mind here is that there are still situations where, at least we've seen board panel decisional law to support this, where benefits could be reduced retroactively from the RFA date, and that's where the claimant's own medical reduced the claimant. So you could still have an IME in that case. Maybe you wouldn't get it reduced to the IME rate, but you can at least get it reduced to the claimant's treating provider's rate retroactively, because that's what the evidence says. The claimant's own medical says it. Now, sometimes what the board will do in that situation, and your mileage will vary with this, and also how you want to respond to this type of issue depends on the circumstances, but sometimes they'll say, at the hearing, I'm not going to reduce retroactively, but I'm going to find that was a TP and not a TT if the claim was a TT. Now, sometimes that's fine. Like if it's a scheduled loss of use case, you might be okay with that because you're going to get credit for the payments made, and it's not going to contribute to a PHP finding. But there might be scenarios where you want to appeal that, and then maybe we'll see if this issue comes to the Court of Appeals or, excuse me, the third department at some point, and we'll get a more definitive answer on that. But really, if the evidence from the claimant's own doctor is lower than the CCP rate, it should be reduced retroactively. But not in this case. Here, where it's based on the IME, the court has taken a position and agreed with the board that the correct reduction date is the date of the hearing. And again, this is an unfortunate decision, but it's important to stay on top of these type of things so that you understand what's happening on your files. We'll be back next month with hopefully a better decision for our side of the bar. If you like this video, please subscribe below. We've got lots of other video series here at LOMAD that I'm sure you'd enjoy. We'll see you next month. Thank you.